principle we use at Acumen Law in defending driving cases is leave no stone unturned. We look for every possible argument, every possible angle of attack that we can use, whether it's a scientific attack on the reliability of a breathalyzer reading, an attack on the officer's credibility through cross-examination, an attack on the manner in which the officer carried out the investigation, looking at violations of your charter rights. Anything like that is something that we are going to explore. We're kind of famous for being a little bit relentless when it comes to advocating different defenses for our client. We never give up. The point is that we want to make sure that we cover every possible angle before our clients could potentially be convicted. And this has led to the great results that we've seen in our impaired driving cases. Client satisfaction is a really big priority here at Acumen Law. We use a lot of different ways to ensure our clients are satisfied with our services and to communicate with them. We provide regular updates after every court appearance by email. If we have a hearing for an IRP or an ADP, we provide updates after the hearing. We have phone calls followed by email summaries of the content of the phone calls, and we use client management software like Clio to track client communications and also be able to share our disclosure that we receive with our clients directly through the Clio client portal. All of these things allow our clients to be informed about every aspect of their case, basically at the same time that we are informed about it. In addition, we have texting on our office phone number, so people can contact us through text message, or they can call our office. We accept calls 24/7 in case of emergency. If somebody's pulled over or arrested at the roadside and it's 3 o'clock in the morning, they can call us. Our clients can reach us via email, and all of the lawyers in our office are routinely checking their email, including on weekends, so that we try and get back to people typically within 24 hours of when they send their email. I've had a lot of challenging cases that have pushed my limits or tested my patience. I think the most difficult ones that I've had have been cases where my clients were innocent. It's, as a criminal lawyer, not always the case that you have completely innocent clients. But there have been cases where I've defended people who never should have been charged in the first place, where it's quite obvious, reviewing all of the evidence, that this person did nothing wrong, whether it was in the manner in which they drove their vehicle, their moral culpability for the case, they didn't consume any alcohol or drugs. Those are the types of people I'm talking about. And those ones are really, really hard to deal with because you feel this great weight of responsibility because you are the person standing between an innocent person and the system. When it comes to defending clients who, maybe have committed an offense, there's a different sensation you get. You're still the person standing between this person and the system, and this person is still presumed to be innocent at law, but your role feels more extrinsic in the sense that you're ensuring the system functions properly, that the person was treated fairly, that every angle of defense is explored, so that the person is only found guilty if all of the evidence can prove that beyond a reasonable doubt and all of the evidence is admissible. It's different in the sensation of it. Other cases that, stick out in my mind are cases where, there have been horrific tragedies. And unfortunately, in dealing with impaired driving cases, that is something that I have to deal with often. Those cases I do struggle with. It's hard. People ask you, how can you sleep at night? And I sleep at night just fine because I know that my role is constitutionally protected. But it is hard to watch the emotional toll that the carnage of car accidents take on communities and people. And having to sit in court and listen to families of deceased or severely injured individuals give statements about how it's impacted their life, nobody can steel themselves so that that doesn't affect them emotionally. And that's also something that really does test your limits as a defense lawyer. You have to be able to compartmentalize those emotions that you're experiencing in those moments so that you can do a good job for your client. Yes. There are a lot of interesting trends in impaired driving law in Canada. I mean, the biggest one is provinces and territories following the scheme we have in British Columbia. In BC in 2010, we effectively decriminalized drunk driving. And now it's an administrative prohibition, license suspension for a first offense. These trends, we've seen other provinces adopt these systems, and we've also seen a trend towards stricter penalties, whether it was removing the curative discharges that used to be in the criminal code, to some of the trends in Ontario of imposing automatic lifetime driving bans on people convicted of impaired driving offenses where there was a death involved. There is this view that the stricter consequences and the more immediate consequences are more likely to lead to a change in behavior. I don't think that that's actually true. Certainly no scientific research tends to show that the severity of consequences of impaired driving deter people, and that there's a simple explanation for it. Alcohol decreases your inhibitions, so you're not thinking about the consequences of your actions when you've had too much to drink. That's the inherent problem in having strict penalties for impaired driving, and potentially deterring people. The other problem is that alcohol also makes it very difficult for you to gauge your own level of impairment. And so if you can't tell how impaired you are after you have a couple drinks, you're not necessarily in the position of being able to make the responsible decision. That's why people need to make a decision in advance about whether or not they are going to put a plan in place to get home safely. AI is a double-edged sword in our industry. On the one hand, you have this trend that people have to try to get AI to defend them. They're less likely to hire a lawyer because they think that they can do it themselves with ChatGPT. Unfortunately, AI does not give you the correct answers or defenses for impaired driving cases. I've explored it. It is not aware of the various defenses. It really misunderstands a lot of the legal issues that arise and a lot of the legal standards that we have. So it's not going to help you successfully defend your case. So that's the negative impact. We also see a negative impact now. We're seeing a trend with police officers experimenting with something called Axon One, which is a body cam system, and the AI software will write the officer's narrative for them after the body cam footage is downloaded. Basically, it watches the body cam and then it writes the narrative of what happened. And there have been documented instances of the AI not getting things correctly, hallucinating things. And that's very concerning when it's in a police report. The expectation is that police are going to review it and make sure it's accurate. But there's really no way to verify that they did that other than their word that they did it. So that's also a negative downside of AI. But AI is also helpful in some ways. If you need, quick scientific information, for example, if you're looking at a calculation of the speed of a vehicle using marks on a roadway, AI is very good for, clean scientific information where you can plug in that scientific information and verify the accuracy of the calculation, as well as identify any analytical flaws in the methods used by the reconstructionist or any other expert. So in that regard, it is helpful to get a sense of where you want to go and whether there may be a need to retain your own defense expert to challenge something, or what areas might be fruitful to explore in cross-examination. That way, AI can be helpful, but it is still always important that anytime you're using AI, you're verifying the accuracy of what its output is with anything else. And I would never use it for legal research because I've tried so many legal research AI platforms and none of them have produced effective or accurate results. Well, I mean, this happens from time to time, that I deal with an opposing counsel, a Crown counsel typically, who is aggressive or, very rare that Crown is unethical. But there have been instances, and I think, the way that you have to do it, when people act that way, you have to respond by maintaining a level head. Take a beat before you respond to anything that they say. Have a colleague read over your response before it's sent. Do something so that there's no reaction that is emotional to their behavior. And if the conduct of the prosecutor or the opposing counsel is inappropriate, there are appropriate applications that you can bring before the judge handling the matter to deal with that, whether it's a prosecutor who didn't get disclosure and allowed it to become destroyed. You can bring an application for a stay of proceedings. You can raise it with the judge. You can argue that there was a failure to comply with the proper procedure. These are the things that you do as a lawyer. When you're faced with these tactics, you have to ensure that your conduct is beyond reproach. Essentially, like Michelle Obama says, when they go low, you go high. And that's what you have to do. And if you come with, clean hands before the court with an application and you say, I don't think that what is happening here is right, and I think these tactics that are being used are wrong, or I think the conduct here is less than this person's standards, and you have a foundation for that, a judge is going to look at that and rule accordingly. First of all, I want to say what it was successfully defending a case. It was a leave application to the Supreme Court of Canada. So we were successful in opposing leave being granted on a case. That case is very important. It actually imposed a requirement that now exists. It's been statutorily written into the Motor Vehicle Act, that officers must provide sworn evidence. And it emphasized the significance of sworn evidence. It continues to be cited to this day in cases dealing with the improper swearing or non-swearing of police reports. So it's a very effective case. And it's also helped to show that even though something isn't necessarily an obvious ground of review in the Motor Vehicle Act, there are still pathways to remedies for non-compliance with the mandatory components of the Act. A lot of people limit themselves just to the grounds of review, thinking this is the only thing that the prohibition can be revoked on. But the court in that case did confirm, and that decision now is the law, that the actions of the police officer, if they fall short of what they are obligated to do under the Motor Vehicle Act, then there may be a route to have the prohibition revoked in that respect. It reminds you to think outside the box, and also to always check all of the documents to ensure there's strict compliance with the statutory procedures. The first thing I would say is if you're pulled over by the police, the first thing you could do to protect your driving privileges is make sure you have your license and insurance documents in your hand when the police walk up to your window. Make sure the window's already unrolled. You don't want to be nervous and fumbling around for these things. Additionally, if you're asked questions, the only questions you have to answer are your name, address, and the name and address of the registered owner of the motor vehicle. You don't need to provide information about where you're going, where you're coming from, who you were with, whether you had anything to drink. But if you are going to answer those questions, do not lie. Lying to the police is one of the worst things you can do for an IRP hearing, because if you are issued an IRP, your credibility becomes significant, and your credibility is going to be assessed based on your statements roadside. In terms of what happens after you've been arrested or issued an IRP, a very big important thing that people should be doing is writing down all of the information that they can remember, as much as they can remember about what happened, in as much detail as possible immediately after while it's fresh in your mind, and label that page "to my lawyer," so that protects it under the scope of privilege. You're going to want to ensure you also start to preserve all the relevant evidence you have about anything that could help defend your case. Go get the receipts the next day from the bar you were at. Get your friends to write statements right away while the incident is fresh in their mind about what they recall happening. Make sure that you download any video camera footage from your Ring camera or your doorbell camera that you might have that might get overwritten in a period of time. You want to collect all of the evidence as soon as possible, and And when it comes to IRPs, you also have a very short period of time during which you can collect evidence, because the hearing usually takes place within 14 days of the date you received the prohibition. So you're going to want to make sure, if you have an IRP, that you're getting on collecting things like medical records and documentation of various, life circumstances that are sometimes harder to get right away, so that you have sufficient time to get all of this information. That I have long or short-term professional goals. I just want to keep succeeding for my clients. I mean, I want good results. I want to ensure that the police conduct is charter compliant. I want to ensure that the police and government are using scientifically reliable methods for testing blood alcohol concentration and testing for drugs. I mean, these goals are sometimes maybe not things that are going to be realized because of the flaws inherent in the system, but they are, what I'm constantly striving for. In terms of what is rewarding about my job, I mean, I love to win. I like winning, which, that part is very rewarding. But I think one thing I find rewarding is when I have a client, especially a client facing a criminal charge, who has maybe an issue in their life that has led to drug or alcohol use. Getting them on the pathway to recovery, helping people recognize, and usually, because it may help their cases, but quitting drinking, abstaining from drugs, that type of thing, going to counseling, doing whatever self-improvement they need to do is not only going to help their case, but it's also going to help their lives get better. And I've seen clients come back years later and tell me how good they're doing. I have a client who routinely sends me his annual chip from his AA meetings for his years of sobriety. And it just warms my heart that these people are in a much better place. And, maybe I had a little tiny way of dealing with it and causing it. Best Rated has certainly had an impact on our visibility. It comes up in a lot of search results. It is something that clients do turn to look for whether or not a lawyer is, well rated and well regarded, and qualified in the area of practice. It has been something very positive. We've been very excited over the last several years that we've been receiving this rating to receive it. We proudly display the 3 Best Rated stickers on our door to show that we are among these, very few specially honored people. And it's, also just really nice. It helps me feel more confident as a lawyer, having that recognition on an objective scale that, the work I'm doing is good and that I am providing a quality service. It kind of like alleviates that imposter syndrome that I think a lot of us have. So it is nice to receive that recognition. And I think having that confidence then allows me to bring that into my interactions with my clients and not second guess myself when I'm making tough decisions about cases or spur of the moment decisions. So it does ultimately have a long-term benefit on my interactions with my clients.